Shall we start? Looks like there's a half of the class. Very first be my brother. Anyway, so last week we have discussed about the concept of cooperation and business forms, right? Today we will discuss about the incorporation of companies, and from today we will discuss about the selected section of the companies. Right? So hopefully I have asked you to have a hard copy or soft copy of the company's act. How many of you got this? Maybe hard copy, hopefully. So okay. So have you seen the company's act? Huh? What is about? So page one, but so we have to again. So we register our sole proprietorship, right? And we also register our partnership. Is that also correct? Right, whatever the business you do, you have to register. The registration procedure of a company is called incorporation. Right? Registration procedure of a company is called incorporation. Even in Sinhala, we call Sansthapaneka. And we are considered company Sansthapaneka. Right? We never will say you need to incorporate your sole proprietorship or partnership. So you have to register this. But company, you incorporate. Registration procedure of a company is called incorporation. What is the special term you think? Then corporation has a special meaning, right? So then it becomes a corporate body. That's a good theory, right? They don't mean it, right? So countries like America, I used to be in the conference, they use INC at the end. That means incorporated. Instead of limited or they use INC. So it's corporate, it's a separate person. Okay? So that is how it becomes a corporate body. Right? So registered for the company called incorporation, hence we call it company or corporation. Right? Okay. When you compare registration as sole proprietorship, partnership, or any other business and compare, what do you think? What is simple, quicker to register? To register a company or sole proprietorship? If you compare, you will think, yes. Sole proprietorship, registration sole proprietorship is quicker, simple, right? No. What do you think? Sole proprietorship, yes. Are you all in the same opinion? Yes. So one says company, okay. Right. Have you ever incorporated a company? No. Any company owners here? Yes. Okay. No one has a company? Yeah, owners, directors, no. No. It was just then. Okay. Right. So, only the command become on the two get the he's okay. Okay, yes. So it's up to you to decide, but probably you might. Do you have any of you have a sole proprietorship? Any sole proprietor? No? No. Investor and business and why is it? Why? So expenses going town. Just for the I'm not going to it's not something, man. Yeah, right. Neil, I don't know call it Castle. An option. I would whistle for the fair side and the papa with it, right? Anyway. So you have to start early, right? No, that's a good idea. Such a group, no one does. Have a down once again. We have to run something, right? So take a pan and something on the back of right? Okay. Right. What do you think to incorporate registration sole proprietorship? How long will it take? To incorporate sole proprietorship, how long will it take, you think? And what document do you want? And where do you have to register? Even if you don't have sole proprietorship, I think you have some idea, right? You all know that sole proprietorship, you have to, it's a provincial subject. Next, registration business is a provincial subject. Because Palasavasha. Therefore, you have to do it provincial, right? Western provincial. I mean, regional math in the process, basically, they follow the same format. Right? So you have to register it at the basically provincial secretariat office. Some province has a separate place like Paris registration office. Again, someone also have done good thing. Right? Right. Okay. Then probably you have to go there. When do you want to go there? Even you know, man, but on the fair on the bank, but on the gun killer, but again, although when I walk over there, some brass for the take money. He never brass for the game, other pay that. He learns something. Okay, right? When you go to the papers, you have to go there when they want you, right? Not when you want to register your business. Maybe, right? and then probably they will give you some photo of you whatever. So there are some documents. Probably they may slightly differ from place to place. Right? And they basically will ask me some type of proof of funds and business place. Right? Then if you don't have business place, hopefully you have at least a leasing agreement. Right? If it's the settlement, then you can prove your address and all that. So likewise, we have to prove some type of address proof. So there are some type of document, ID copies and so and so. Right? Likewise, then that is how you have to do it. Then sometimes some people even want to see your face. So they want to visit your place. When they want to visit your place, then they want to transport. Then you have to pay. Once you pay, they will come. But there we are. Those type of things are there. Right? So that is how it happens. Then according to the wish and relationship and whatever, they will get it registered, maybe 2 weeks, maybe 2 years. No one knows. So that is how it happens. Right? Someone sort of company. We discuss how to incorporate a company. Right? So, under this topic, we will discuss about how to incorporate a limited company. Right, so end of this lesson, you will be able to identify the procedure of incorporating a limited company under the Companies Act and explain the result consequences of incorporation and also discuss the rules related to the company name. So that's what we're going to learn today. Right, so this is our lesson today in a nutshell, right? The applicable laws, what is a company, different type of companies, how to form a company is our main focus today. And then we'll discuss that here. Second part, we'll discuss rules related to the company names. Right. So I asked you to have a Companies Act, but it is obviously the most important document related to companies, but it doesn't say it's only the companies that there are some other laws which are also part of the company. Especially they are part of the public companies, right? For the limited private companies, sometimes don't good governance best practice here, but almost all others are also part of the company. I have mentioned some of them here. So Securities Council Act, same act which is very new, passed in 2021, and CSE rules and regulations only applicable to listed companies. And then the Takeover and Mergers Code, Unit Trust Code, Best Practices Code, right? Likewise, there are some other laws. Basically, they are part of the listed companies. Most important document related to companies is nothing but the Companies Act number 7 of 2007. And the second important document is the probably articles. Okay. Right. So we have right Srilankan case here. Decided in 2003. Yeah.
Sir,
Yes.
we cannot see the smart board, sir, please.
You can't?
We cannot see it. Yes, sir. I think it's not shared yet.
Is it okay now?
No, sir, not yet, sir. We can see only you.
Not enough. 3 weeks. Or you wanna? It's something else, right? Can you see now?
Now perfectly done, sir. Yes, thank you, sir.
Okay. Okay, right. So this is the one of the definition given by Justice Signature about the definition of a company. Right? So this is Sri Lankan definition. So it is decided in 2002 in this court case. He says the only difference between a natural person and a company might be the fact that a company is a legal entity, not just with bone, marrow, and flesh. But the company has to work through human beings. Right? So throughout the last week, we discussed a company is very similar to a human being. Right? So he also says the only difference between the natural person and artificial person. Right? So in company law, we divide the person into two as natural person, person like you and me, and the artificial person is the company. So he says the difference between the human beings and the company is that we have, yes, he says we have a company is a legal entity blessed with bones, marrow, and flesh. Right? The company don't have any of them. Me atamak midru mukut na company, right? Even nothing in tamak company. So we have all those things. That's only different according to the Justice Vignesh. And also he says, but the company has to work through a human being. That we have also discussed. So even though the company is a person, right? It's like a Iron Man suit. Right? Without the involvement of the natural person, it can do nothing. From the natural person in it, it can do what? Right? So company is the same. So definitely company needs the help of the natural person to get their things done. Those natural persons are basically who? Kawasani company. Basically, we can say either board of directors or shareholders, maybe both, or even maybe any person appointed by the company. Right? Maybe any person appointed by the company, but those people are, we all know, basically, act is done by the shareholders and the company. Right? Right. So, in comparison, do we have a company act now? So, 529 is one of the important sections. We call it interpretation section. According to the modern trend, the interpretation section is set out at the end of that. Right? According to the old law, it is at the very beginning of the law. Right? Now it is at the end. So according to this section, define terms in relation to the companies. If you want to know what is a financial statement, then you can see the section 529. If you want to know who is a director, then you can see section 529. Right? If you know what is a balance sheet date, then you can see section 529. It defines them. It interprets them all. Right? Accordingly, interpretation section interpret the company to mean company means a company incorporated under this law or an existing company. Right? Therefore, we can say a company if it is registered under the Companies Act. Right? So then, under section 3, right, it says what type of companies we can incorporate here in Sri Lanka. Accordingly, section 3 says 3 types of companies can be incorporated in Sri Lanka, namely limited companies, unlimited companies, and the companies limited by Galle. What's the limited company? Limited company is a company which issues shares and the liability of members is limited to the shares they have bought. Unlimited company is also a company which also issues shares. However, the liability of members are not limited to shares. And the company limited by guarantee is a company which does not issue shares. In Sri Lanka, guarantee companies, they don't issue shares. However, liability is again limited, but not to the shares they have bought, but to the amount they have agreed to pay at the event of winding up. So those are the 3 types of companies that we can incorporate here in Sri Lanka. And by section 4.2, there's a special recognition for the single shareholder companies. Right? So now, hopefully you all aware that company can even be incorporated with the one person. Are you all aware of that? Have done not? Take it to a company done that is right. Even for a partnership, you have to have two persons, but for a company, you yourself can incorporate a company. Okay. Is it good? You have your own company. But it is there's a company private limited artificial person who owns it. Myself. Right. Is it good budgeting? Single shareholder company. Are you happy with that? Or do you think that at least good to have two members? Who is it? Can you model public equity? Huh? Who's that? Yes. Mangalu Titani. Yes. Mangalu Bimban, a moment at us. Marine and a moment at yes, what it is. So in fact, that's what happened now, right? Before 2007, there was a requirement of two members. Just because of that requirement, what you did was you make your wife a partner and give her one share, 99 on by you, and she even doesn't know whether she is a member. After the guy, right? Take a share, from Mangal. So in fact, they were also single shareholder companies. Right? That's one reason to recognize the single shareholder companies, even though they have the requirement of two or more, still they were controlled by one person. Right? Sometimes husband, son, whatever, they even don't know whether they are shareholders. Right? So therefore, court decided the time has come to start the single shareholder company. And also in that way, they tried to formalize the business, transferring almost all the sole proprietorship into a limited company where they have some type of measure to trace when things happen. Right? So therefore, yes. So court recognized a single shareholder company by section 4.2. And with the amendment passed about 2 months ago, now it has made very clear that in Sri Lanka we can incorporate single shareholder companies. The only requirement is that when there's a single shareholder company, 100% share belong to one person. That is why they have got single shareholder companies. However, sole director cannot act as a sole secretary. Right? That's the only requirement. Then you can be a director and 100% shareholder, but either you have hire a secretary, or you can have all shares belong to one person, 100%, but you may have two directors. Then you can be a director and secretary, and can be a director. Okay. So right. So we basically like to incorporate a single shareholder companies. Why? First, I really like to incorporate a single shareholder company. When you incorporate companies for each director, you have to file a separate form. That costs 2,000 plus that. We bahak kita, tapi gana, 10,000 plus that. 2,000 plus that. Itu ada sampai dalam. And even the what you have for also minimum. Then there's one person. Right. So, and also it is easy now. Nowadays, you know, it was 7 long time ago. Right? It was 7 members at that long time. Therefore, this was reduced to now it is one name. Since all the Hataka kitchen, they get it. It was the day. Then I'll give you benefit. We burn to this and over to that town. Let's come on the so probably they have Yes, recognize the single shareholder company. So, how to form a company? Like, if you want section 42, this is the section 42. However, this section is now amended. Right? So, this section is, I don't think anyone can understand this section. So, there's a reason to amend this law recently, right? Make a recently amended law. Make a because given middle table, what does it say? The throughout the companies that you will say the law use the two terms shall and may. That's a legal language. The legal language is the act treat able to use shall and may. Shall means mandate. May means optional. Right. So it says the company shall have not less than 2 shareholders. Provided that then there's a provision, a company may have a single shareholder. That single shareholder may be a government. Secretary of Treasury means the Secretary of Treasury holds the share on behalf of the government. That single shareholder may be a government, corporation, or individual. Then is there a meaning? After Haria, එකෙක් වුණත් ඉන්න පුළුවන් ඒක කම්පැනියක් වෙන්නත් පුළුවන් රජය වෙන්නත් පුළුවන් ඕන එකෙක් වෙන්නත් පුළුවන්. So the reason, if I go to explain everything takes time, right? The reason is in the first time it was only says the company may have a single shall have 2 members, may have a single shareholder, that single shareholder may be a corporation. That was the original clause. Then there's a company down the Then in the parliament it was amended, no, the government also should have a freedom to incorporate single shareholder company. Then it says that single shareholder may be a corporation or government, secretary to the Senate. Right. Then at the last moment they said, no, now Tawin has the country, it is a single shareholder company. It is also recognized in the level of jurisdiction. Therefore, we also should accept it. Then very clearly they did both. They just say, oh, an individual and no pass. That's the reason to have such a vague provisions. However, in practice, there are a number of private limited companies they have incorporated with the single shareholders. There's nothing wrong with that. It is prevailing in Sri Lanka. And to, yes, probably to minimize these language issues, with the new amendment done about 2 months ago, now it says in Sri Lanka that the company may have one shareholder guarantee, right? 2 guarantee, 1 guarantee. However, even I have issues with that amendment as well. This is about the limited company. So my question is, I'm not going to because I have a huge issues with the Sri Lankan law recognize the public company as a single shareholder company. Right? For the private companies, it's okay, right? But this law says about the incorporation of the limited company. But I don't think it is suitable for a public company to register a single shareholder company. Therefore, I think it should be properly passed law as private limited companies may have a single shareholder, but not for the public company. But according to the new amendment, that is also not clear whether what is the minimum members of public company. So I hope it is 2. Right? Let's see. Right. So section 4.1 is all about how to incorporate a limited company. Because incorporating is a guarantee company is different. Incorporating offshore company is different. So this section says how to incorporate a limited company. However, in Sri Lanka, almost 90%, maybe more than 90% companies are limited companies. Right. So how you can incorporate a limited company? What do you want to incorporate a limited company? Company incorporate $1. Yes. Company incorporate $1. Online people, can you hear me? Online people, can you hear me or I am doing something else? So they have switched on their laptop and doing something else next. When you are, yes. Other side is money, time is money. Right. What do you want to incorporate a company? Practical. Lanka company incorporate करना वाला बना दो. Yes. Right. So first you have to find the company name. Okay, good. What then? Forms. Right. Okay, very good. Yes. What else? Okay, really good. And what else? You want someone like me to get it done? Secretary? To get it incorporated, can you do it yourself or you want some help? Yes. Of course, you know, the number of Islam companies can only be incorporated on name. You know it? Yes. No physical registration in Sri Lanka, right? No physical registration. Companies can only be incorporated on. So you have to have a laptop with the internet connection, right? Then only you can even think of name or what, right? Without which you can't incorporate a company in Sri Lanka, right? 100% digital, right? Take online which I can run Islam or right? Then you have to create your own account. That case we want it to be. So something like account create the then you can select company. Then they will ask some information like your name. They won't ask the unnecessary things, right? Your name, date of birth, right? Sometimes when you write your ID number, all other comes automatic. So like nowadays, you know, there's no privacy. ID number is auto. So now it's screen rather than the second one, you are right? Then there are forms, even the forms, they will appear with field form. The Kalima numbers, ID numbers, form just fill belongs to it. There's nothing you have to do. Right? Anyway, there are some phases that you have to fill. So only thing is that you have to fill on the total side. Right? So obviously you need to fill 3 forms plus articles of association. Once they are done, then you have to get the print out. And then you have to sign. And then scan and upload. And then you have to make a payment, obviously with the credit card. And then within 2-3 days, you will get the soft copy of your certificate of incorporation. From that day, your company is incorporated. So it's done. That's it. And that's nothing. So that is how you can incorporate a company. Hopefully, you all can get a company incorporated. It has become such a simple thing to incorporate a company. Not a hard doing platform. That's hopefully the main reason to pass this law. Yes. Among others, the main reason to pass this law in 2007 is to simplify the registration procedure. Right? So I hope it is 100% actually. Right. So now the incorporation of company has become very simple thing, right? So this is what it says. Who can incorporate a company? Any person or persons. It then says single shareholder companies are accepted. So it use the term any person, singular, right? Any person or person. Right? If you look at the section 32, which is about incorporation in a guarantee company, that section will start with any 2 or more persons. Because for a guarantee company, minimum members are 2. But limited companies start with any person or persons. Therefore, it also says single shareholder companies are there. May apply to incorporate a company by making an application to the registrar in the prescribed form signed by each of the initial shareholders with the following document. Therefore, these are the documents, nothing else. Right? Whether ever done the public. You got a what are the documents need to incorporate a company? Route plan, identity, copy. Only the month. You don't need it. They don't update it. Right. They only ask what do they ask? They ask for declaration. That is form 1. That is application form. That's one thing now. Right? This is asked for declaration. It's called declaration because in the application form 1, there's a statement that it says the proposed company name is not similar or identical to that of an existing company. At the end of that statement, initial shareholders have to sign. So that is why it says declaration, because you have to declare that your proposed name is not similar to that of an existing company. So therefore, form 1 is also known as the declaration. It is form 1. And then, to incorporate a company, you have to have articles of association. Oh, what is that? How to make this one? Make a model. Right. Kung articles ko boleh saya mendengar lagi namanya. Hari ini komputer. Komputer. Act. If we have act, there are schedules. At the end of that, there are about 15 schedules. The first schedule to that is the model articles. You can have a look. First schedule to that is the model articles. Once page 444 again. Right. Actually, page 444 again. First, so the model articles. First schedule to that. So 90% companies take the model articles as it is. They have very nice draft. What they do is they take the model article as it is, and at the end they sign. Therefore, it is not such a complex thing to do. Right? Over articles of association, අපි ගන්න තාපුවම නිකන් අපි ඔක අපි හදලා අපි ඩ්‍රාෆ්ට් කළා වගේ හදලා දෙනවා. නැත්තම් අපි ගන්න බෑනේ. නේද? අපි මොකද කරන්නේ? ඔක කොපි කරලා තියෙනවා. right? අර පොඩ්ඩක් බයින්ඩ් ඉස්සෙල්ලා තියන්න ගන්න බෑ. නේ? එහෙම කරලා නැත්නම් ඕක තියෙන aspect, right? So it is nice to draft. There's nothing wrong with that. So 90% companies adapt the model answers. Limited companies. Therefore, it is also simplified. One simplify කරලා දෙන හැටි නේ. एक तरफ incorporate काम, right? Model articles दीना थी. Articles समझते do you need to mention what is the purpose and objectives for the answer? No, it is. Compare the answer. But don't need men. Develop as well. Go ahead, that. Articles. Right. Or not, it's Dagani. Personal name, not Dagan, you can't take the model. It is not mandatory at all. It is not compulsory at all. It is also simplified. Here, simplify, right? But lower the government. Right? No private companies are required to have objectives. There's no objectives in the model arc. Right? Companies right? So there's no objective because you can incorporate the company to sell chocolate today, tomorrow you can sell shoes. There's nothing wrong with that. That's a new company, right? So you don't need to have objectives. So that is how company we have simplified the registration code. Right? And then what else you want? Then you want to have to run a company, you have to have a director. I got. Yes, if you are waiting and this is good mind, all of you can act as a director. Right? Any person with a good mind and over 18 years of age can act as a director of a company. So that director has to give his or her written consent to act as a director. So that is Form 80. To incorporate a company, you have to have a director, and throughout the company, you have to have a director or directors. So they have used their written consent. That is Form 80. Form 18 කියවලා එක page එකයි හොඳේ වචන 100ක් අන්න. Name, birthday, address. That's it. Right? Designation එක ඕන නම් දාන්න නැත්නම් ඒක ඕන නැත්නම් නෑ. ඒක වෙලු තමස් ඉස්සරහ නැහැ. හොඳේ date of birth තමයි because directors have to resign at one point. Right? Then company also have to have a secretary. The secretary. That depends according to the company's need. It's total capital and the turnover. However, as initially, even any person can act as a secretary as well, or if not, you can contact a lawyer or chartered accountant. No, then they can act as a secretary. So it is also only one page. Right? So those forms will come automatically now, right? Where director or secretary now, right? Make this director, secretary, think about the make this shareholder, director, think and take field, right? So it is very simple right now, right? So therefore, that's all you have to do. And given a form form 18 one page, form 19 one page, form 1 2 pages, it depends on the number of directors. Articles is about 22 pages, but that is given by the company staff. So then you have to take a printout, sign, and upload. Right? And make a payment. The payment is 4,000 for form 1, 2,000 each for other forms, plus VAT and individual. Then you will get your company incorporated. Maybe within 1 week, probably within 2 3 days, you will receive a certificate of incorporation. It is also printed as a soft copy. Right? Then your company is incorporated. That's it. Right? Okay, thing along gives a video again. Mana Savana was ඔක්කොම දාගන්න ගියා පස්සේ කම්ප්ලීට් ගියා ඔයාලා හැන්ඩ් ගියා සල්මත් දාගත්ත ඒක සල්මත් ගියා නේ රයිට් ඔය මොනවද බලන්න කම්පැනි නවා කම්පැනි දෙකක් ඉස් කම්ප්ලීට් කරලා right it is simplified as that can you register the sole cover checking you know in midnight කිතල්වත් පුළුවන් පැදුරට තමන්ගේ සෝල් පවර්ෂිප් එක රෙජිස්ටර් කරන එකක් හිතන්නවත් පුළුවන්. පැදුරට නෙවෙයි. නිවරුදු දවසකට වැඩ කරන දවසකට උන් කියන දවසට යන්න. බදාදෙන් කියන බදාද යන්න ඕනේ. So company you can incorporate at any time, any place in the world. Right? Even online people, whether you are Dubai, New Zealand, whatever, you can incorporate that company here in Sri Lanka when you are in Dubai or New Zealand or whatever. So we simplify to that extent, right? So that's all the way. So that is how you incorporate a company, right? So you can compare, right? What is simple? To incorporate a company or any other business, right? You can compare and see whether you can get other things done in that way. As far as I know, there's no online registration for other type business, right? Of course, there are. Yes, you can argue that there are some formalities. There are some formalities. So there are some formalities, but it is also for the private limited company. There are no more formalities. Only thing they do is to file the annual return. Even many companies even don't file the annual return. There's one form in the OEM. Right? Therefore, there's no formalities as we think. Right? The only main requirement is to file the annual return. So if not, you can run your private limited company just as your sole proprietorship with all those rights and privileges. Okay. Right. So that's how you incorporate a company. So it has been simple as that, and they don't ask you the identity copy, the bank account, the road plan. Nothing will be required. But if you want, there are links where you can go for a tax in your revenue, where you can go for a labor laws, PPA, PTF, and all, there are revenues, there are links. If you want, you can do that, but anyway, you can simply see. Right? So that is how you have to incorporate a company. Right? That's simple. My spice is income like incorporate company, right? So you all can do it. You can get to incorporate a company. Can easily charge 50,000. Cost is about 20,000. Right? So lowest charge from 50,000 to 500,000 no one. Looking at basis. Appealing to that one, right? Looking moon for that, and in a fella. But after that's about that. So the virus one. No 500. So normal really can government keep there and out. When this state can house, last time. They will come, I guess, all the time. What it does something like? What it does something? They will come, like Mr. Moonbara, like that. Hey, by another incorporate Canada, for the second you can take it and do it with me. Right? So get about 60,000, 70,000. I can give you 20,000. Right? By another company, incorporate, right? Market Gata, come on, and the money. 7,000. Right? Okay, so that is how you incorporate a company, right? Any question about how to incorporate a company? How to incorporate a limited company that we discussed. How to incorporate a limited company. It is simple as that, right? Make it easy. Once company is incorporated, then you will get the certificate of incorporation. You have all seen this, right? This is the certificate of incorporation. Right? So every company has the name and also a unique number. For the private company, this number comes as a PV. And probably start with 00, so this is how you can see this is a private company, that is I start with PV. Public companies come with PQ, right? And then it says the company name in Sinhala, Tamil and English, right? All three languages. And the date of birth, 12th day of December 2020. Right? And then as with a soft copy, it says a barcode, anyone can check with this original. Right? And then it also says whether it is a private company or whatever. It's a private company. Right? So this is a certificate of incorporation. Right? So nowadays, this only comes as a soft copy. But if you want, you can get a printout. But this comes as a soft copy. Right. So section 5.1 says on the receipt of properly completed application, the registrar there are two other particular in the company on the list. Every the registrar has a e-file for each and every company. So they will enter all the particulars in their e-files and then they assign a unique number to the company. Then there will be minimum misunderstanding because sometimes there are similar names, right? US car sales, VS car sales, but they have a two different unique numbers. Therefore, whenever you write the company name, make sure write the company number. It's very similar to an identity number of a natural person. In any legal document, you will not only write your name, but also you include the NIC number as well. Likewise, company's NIC is the PV number, registration number, right? And then in this certificate, you saw the name and number is there. the birth date based on which the company was incorporated, whether the company is a private company or offshore company, those particulars are there in the certificate of incorporation. Once you receive the certificate of incorporation, it is very similar to a birth certificate of a company. Right? एक हाजिर company के लिए ना birth certificate का पाए तो आप birth certificate का पाए तब आई company certificate of incorporation. Right? So there's all those cases have reaffirmed that once you receive the certificate of incorporation, it's a conclusive evidence show that there is such a person and it was born on that day and they have complied with the legal requirement. Right? So my certificate in like right? And they have complied with the legal requirement. Right? From that day, that time there is a man. Right? Take a card and then to have a certificate of incorporation. Right? However, the registrar will not register a company for an unlawful purpose, but nowadays, object clause is an option. But before 2007, it was must. Right? Because 1992, there was a requirement of object clause. Mandatory. It is mandatory for some companies, but not for the limited companies. Is there a company can be engaged in a very sattam? So, one was the difference. We also compare the company with a natural person. As a natural person, you can do anything unless prohibited by. Is that correct? As a natural person, you can do anything unless prohibited by. But company, especially before 2007, when there was object clause, can only be done what law permitted. All others are. Right? Did you get it? Company can only do what law permitted to do. Right? All others are prohibited. If a school is incorporated to do a higher, postgraduate or graduate degrees, then that's the only thing they can. Nothing else. All others are fine. Right? That school degree program for something. Private school because it only can do what law permitted. All others are prohibited. But as a natural person, we can do anything under permission. That was, and even still today, so that's one of the main difference between the natural person and the artificial person. Compare them with some purpose. Private school, private private school. They only can do what law permitted. That's the one main difference between the natural person and the artificial person. Right? So those are some of the implications of the certificate of incorporation. It is very similar to the certificate of a company, right? So it has a company number which is unique identification number for the company, and it is conclusive evidence that all requirements under the law have been complied with. Right? So once company is incorporated, now there's a person. Company become a natural legal person from the date of incorporation. Right? So then, upon the certificate of incorporation being issued, then the company become a body corporate. With the separate legal person. Separate from whom? Separate from those who form it. Separate from those who own it. Separate from those who manage it. So company becomes a separate person from shareholders, promoters, and the directors. Right? With separate legal person identity, that of its creators. Yes. In the eyes of law, it's a legal person, distinct, different, and separate from its shareholders. So this is a metaphysical person created by law with a legal but no physical existence. So I repeatedly tell you that company is a fiction. It has no physical being, but it enjoys all the rights and privileges enjoyed by the physical beings. Okay. So accordingly, these are some consequences of incorporation. Right? Once incorporated, it becomes a separate person. It has a perpetual succession, continuation. We discussed about the limited liability company, so the liability is limited, and the shareholders can freely transfer their shares, and also with powers and also increase. So company is a separate person. Right? What does it mean? Now we say that if you have a sole proprietorship, who own the properties or assets of the sole proprietorship? All sole proprietor, correct. If you have a partnership, who own the properties, assets of the partnership? Partners, all. If you have a limited company, who owns the assets, properties of the company? Yes. Shareholders. Company. Shareholders. Company. Shareholders. Pala hari naman kita pala hari naman ka. Banyak tu. That's a different line, right? That's why company different from other type of business, right? Company is a separate person. It has the capacity to have its assets. So company's assets, company's property belongs to company itself, not to the shareholders or no one else. Because company is a person who can pay that, right? Did you get it? And what's not there? You know, company property capital guys with the shareholders are right? So that is how share market is created. So they have buy. That is it. But it doesn't mean that they belong to it, right? Not at all. You have some idea company. Company's property belongs to company itself. That is called separateness. Right? For example, on right. And also it has a perpetual succession. And I will explain it further, right? Perpetual succession. Continuation. Make a legal term. Make a continuation. Company never dies. Once incorporated, it continues until the winding up of this solution. Right? Itu memang good very nice. Right? So, apa itu? Megoldan Tino. Company, after that, you have a company, you form a company in 2000. 1990, you have a company formed from other. Right? It was the 2000, remember? Right? 2000, right? 2002, remember? Right? I become a monk. Right? One leave for Canada, another one become a monk. Right? And another one was caught selling drugs. Now in prison. The fourth one naturally dies. Now what will happen to their company? Yes. What will happen to their company? Yes. More than a company doing. So this is a couple of company. This is a couple of company. One leave for Canada, another become a monk, another was charged with the criminal offense that is in prison, the other one naturally dies. So what will happen to their company? Company more than again. Yes. More than a company. Huh? Company continues. Company continues. It still has to pay tax. You can say whatever they do. So the change of shareholders, owners, they are dead, right? They are leaves, right? Nothing will affect the status of the company. Company can, because company is not you. Company is a separate person, right? Company is a separate person, right? So obviously, some people will come. Maybe you are next of king. Maybe company doesn't go to heaven, right? We go to its next of kings, right? We the given the andiva, the heaven the answer of the ending. Apina may pull the Dagaran and the member of the Tanga and one is you. But every time that is member of Srilanka, the people, Kirane. With Sarah Santika, member of the audience. Or you will go to the lawyer, but not company. If you go to the, if go to the next of king. Or legal here, then they will come in. Compare, you run it, hard I three compare. So now compare is open 95 under field management. It runs. Did you get it? That's a compare. Because it's a separate personnel, it continues. Right? The change of directors, so shareholders does not affect the business of a company. Right? Is it clear, students? Okay. And also, liability is limited. Whose liability is limited? Company's liability or shareholders' liability? Yes. 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 That is liability. Liability limited means the shareholders' liability. They are liability limited to the shares they have bought. Company is a person like you and me. Company's liability is unlimited. Company is a person like you and me. Liability is unlimited. But what is limited is the shareholders' liability. So their liability is limited to the shares they have bought. So their home is safe. Maybe 60% is safe. Only liability is the investment. So creditors cannot take the personal assets of the owners of investment. They only can claim what is belong to the company. Right? And also, in a company, shareholders can freely transfer their shares. It's a listed company, you know, CSA, there's no restriction at all. And also, borrowing power is increase in the company. So those are some of the results of the incorporation. For the time now. 140. We can't give it. Okay, have a break. आता आपण जर ऑनलाइन जर जोडलं आहे ना मी पाहतो तिथे आवेदन टाकल्याने लोक So I think 19, 80. It's up. Yeah. First of all, some two. Question mark.
Hello, sir.
Yes.
Sir, there is an error in this QR code.
Yes, that's okay. Okay. Right, until others join, we will see. Now, let's see. He has a complaint. The sole shareholder and the director. Complaint name is, let's say, Juicy Fruits Private Limited. Right? He has a company. His company name is the Juicy Fruits Private Limited. One day, this company has sold his spoiled juice to a customer. Right? He is the customer. Right? Now, as a result, she got a strong case, and then she filed a case. Who is liable? You or company? Another Mr. Juicer, Juicy Fruits Private Limited. The company is liable. Maybe somebody has to represent the company before the court. But he had to go to the court only as a representative. But you can't sue against him. Even you can send maybe lawyer, maybe secretary, maybe CEO. Somebody has to represent the court, but he's not that one. Of course, you have to sue against the company. Company a person just like you and me. He can enter the country, be sued that. He can sue against something. Okay. Right. Another. Now we discuss in detail about the separateness again. Like now we know the law, but we discuss it again. Separate legal person, and this separateness of a company, right? So Juicy Fruits Limited is separate, Mr. Juice is separate. Is separate. Right? So this separateness in law is known as legal term, way of incorporation. Once company is incorporated, there's a way. So you can't go through the way. What's behind really is the shareholders. So you can't go shareholders are not right? So in legal terms, this is known as the way of incorporation. So we have already discussed these things. So legal person law recognizes two types of legal persons as natural person and artificial person. Natural persons are the person like you and me. Artificial persons are the corporations. They are created by Parliament, maybe by General Act, maybe by Special Act, maybe by General Act like Companies Act. So if any business incorporated under Companies Act, it becomes a corporate body. So this is in legal term known as the way of incorporation. Once company is incorporated, it becomes a separate person. In Sinhala, we call it Sanstha Paudgalika, right? Whenever Paudgalika meaning, right? Okay. This separateness of a company is recognized by the Companies Act, right? So we now already know that the company is separate from those who create it. owned it and managed. It is a separate person from promoters, shareholders, and the board of directors. And this is recognized by the section 2 of the Companies Act. You can refer section 2, right? So section 2 says a company is a body corporate within and outside Sri Lanka. If properly incorporated under the Companies Act, the company becomes a body corporate within and outside Sri Lanka. Incorporated කරපස්සේ Sri Lanka පිටත් Sri Lanka ඇතුළත පිටත් වෙනම මිලේ වෙනම සංස්ථාවක් පුද්ගලික සලකනවා කියලා කියනවා. So it further says that it has the capacity to carry on or undertake any business or activity, to do any act or enter into any transaction may be subject to articles. And it further says it has all the powers and privileges necessary for that purpose. Right? So that's a compensation. It's very clear. Comparing problem any activity into any contract transaction, and it has all the powers and capacity privileges for that purpose here. So therefore, company can enter into any business just like you and it. So section 2 and also says a company is a body corporate identified by the name by which it has been registered. So by that name it becomes a separate person. And there are some other sections that say throughout the company, especially section 87 says a shareholder shall not be liable for any act, default or an obligation of the company by reason only of the being a shareholder. Therefore, it clearly says that shareholders are not liable for any act of the company. Then who is liable for the act of the company? Yes. If you get a shareholder, you can take a liable. But because of the owner or shareholder, they are not liable. Then who is liable? Company itself. Company itself. Say as an example, a company, they are company, get a loan for, let's say, 100 million. Right? So their contribution is only 100,000 each. Now the company failed to repay the loan. Who is liable to pay? Now company file the case against the comparison rate of loan. What is your liability? Each of them, what is their liability? What is their liability? 400 million, but it's your liability assets. Shareholding. See. Yeah, what? 10,000 shares, 10 rupees each. Yes, each has invested 100,000, but they have bought 10,000 shares, 10 rupees. But the company has taken the 100 million. Now they have failed to repay. Now they are liable. So you believe they are liabilities. No liability. What do you think? Okay. What are you? Yes. Wait. The A, B, C, D, and they were liable. Not liable. Wait. What will happen to the investment? 100,000. You can take it back. Huh? Why you can't take it back? Huh? Yes, your liabilities. You are liable for 100,000. Right? Your liability is limited to the shares you have bought. Right? Therefore, your liability is limited to the 10,000 shares into 10,000. Right? Liability is right? So your liability is limited to that amount, the shares you have bought. but not for the 100 million. But your liability is limited to the 100,000. That's your liability. In fact, what you said is also correct, because if he has already paid, then there's no liability. But I don't think you thought that part. If you already paid, then there is no liability. Right? If a pay person is not paid, then you are liable to pay. Right? So anyway, their liability is limited to the shares they have bought. So they have bought 100,000 per share, so their liability is limited to the 100,000. So that amount they are liable, no? So members' liability is limited to the shares they have bought. They can't give it, right? So their liability is limited to that. But your home is same. Other fixed amount, other assets are, they are same. They are protected. But the investment, there's no guarantee, right? It's belong to the company. So that 100,000 belong to the company, you can't take it back. Right? Is it clear? So your liability is limited to that amount. Right. So but we are not liable for the 100 million. Right? So this separateness recognized by the companies Act Section 2, Section 8, etc., also recognized by the court all over the world by hundreds of cases. So we discussed few of them. This is one of the very classic case in company law, decided in 1897, history of the law. Salomon versus Salomon and Company Limited. I want all of you to read this case. Right? This is such a classic case. Still people do research on this case. Right? So the fact of this case, this is the time in England where the concept of cooperation was becoming popular. Before that, it was the partnership that was more popular than the cooperation. So Solomon was a boot manufacturer. He had a boot manufacturing. He was a boot manufacturer. He had a boot manufacturing. He was doing it for about 30 years. So when he doing business, he had some creditors. So especially there was a strike in leather industry at that time in England. So therefore, he also stuck in this strikes. So he got some credit from the outside creditors. They were not safe. So in fact, his boot manufacturing was worth. He sold into the company. So he decided to converting his business into a limited company. He sold a partnership. What he did was he sold his business boot manufacturing to the company he formed. So the members were Solomon was the main member and his wife, and he had 6 children. He selected 5 of them. Then 5 children, wife, and Solomon are the shareholders because at that time minimum members were 7. Right? Then he sold his boot manufacturing to the company he formed for about £4,000. For this £4,000, company issued 20,006 shares, one share, £1. 20,000. Out of these 20,006, 20,000 shares belong to the Solomon. And 6 shares belong to the 1 for wife and 1 for children each. So that is how 20,006 shares. So that 1 share, £1. And for the balance, another 10,000 debentures were issued. All debentures were belong to the Solomon. Balance were taken as a cash, almost another 10,000. Next, exactly 9,994. That was paid by the cash. That was the transfer. As there was a strike in the leather industry, he couldn't complete his orders on time. Therefore, he got some credit on the outside creditors. They were unsecured creditors. So, however, as his strike went on, he couldn't pay them to the creditors. Then those creditors filed a case. In this case, as case was before the court ordered to collect all the assets of the company. At that time, all the assets of the company was worth only about £6,500. company of outside creditors, 7,000 pounds. For the Solomon, 10,000 rupees. Then the outsider creditors first file a case before the district court. Then the district court, outsiders, unsecured creditors argue that Solomon and company are the same. This company is a public company. It's controlled by the Solomon, 12,006 shares. Therefore, one cannot owe one to himself. And then, as outsiders, we must be paid first. In fact, district court judge accepted it. However, Solomon was not happy. Then, against this decision, Solomon filed a case against the company. This is the case. Solomon's argument was he should be paid first. Because company owed him 10,000. Then in this case, English lords in the highest court, they discussed this matter in detail. This is almost the very first case they discussed about the company's concept of cooperation and all. Then the similar positions were they are similar to section 2 in the Companies Act. So it says once company is properly incorporated, it becomes corporate but separate person. Then the House of Lords, those lords decided whether this is a properly incorporated company. Then the Companies Act says there must be 7 members. There were 7 members. In that, there were no any restriction that wife cannot be a shareholder, children cannot be a shareholder. There were no such restriction. Only requirement was 7 members. 7 members were there. And then all the forms were properly done. Payment were paid. Then court decided this is a properly incorporated company. According to the Companies Act, if a company was properly incorporated, then it becomes a separate person. Then the Lords decided now, as it's properly incorporated, Solomon was a separate person, Solomon and company that was a separate person. If there were 2 separate persons, then the judges was of the opinion that it is possible that one can owe one to one, as they were 2 separate persons. Then they applied how to distribute the assets in the company. Go to the company law. That's our last specified now. In the company law, first paid the secured creditors. Unsecured creditors are paid last. Debenture holder was a secured creditor. It was filed by the unsecured creditor. The court decided as a secured creditors. Secured creditor, who was the secured creditor? Debenture holder was a SARS. Court ordered to pay his 10,000. And then company only had 6,500. Right? And ordered the other parties to pay the cost of litigation and go home. So that's a Solomon and company. What does this case say? That's the concept of cooperation, right? After this case, right, it was there. Yes, it's like a boom for the private sector. Right? So it is this case that, yes, recognize that even if you own the company, still you are separate. You can do business with your own company. Right? You can be a director of your own company. You can be the creditor of your own company. You can be a supplier of your own company. Right? So because once incorporated, company is separate, shareholders are separate. Right? Is it clear? So, therefore, this is a very landmark case. Now, this case is also known as the Solomon separateness is also known as the Solomon case. Solomon case. Because main case again, the other best chapter is separateness case are not Solomon case. Solomon rule case. So you can see he was the main shareholder. He was the controlling shareholder. Right? But court decided he is separate, his company is separate. Right? Is it clear? You can stop me at any time. 1.3%. Right? Right. So the debt of the company is on and not of the its members. Next. And therefore, yes, shareholders are not liable in any shape for the act of the company. Right. So this is known as the separateness, way of incorporation, Solomon rule. Right. Once company is incorporated, there is a way. Right. Once company is incorporated, there is a way. What is behind the way? Shareholder. So the companies act, you can't go through the way, right? That's the way. You can't make the shareholders liable. Because you can't go through the other way. Right? Because they are not liable for the companies that company itself is liable. Company got a company from a liable with, right? They do liable with that is called separation. Way of which corporation. Therefore, they are not liable for the act of the company. Right. So, latecomers, you have to learn the very classic case in company law, Solomon versus Solomon and company. Okay? It's a very classic case. So, let's see another case. Lee versus Lee's Air Farming Limited. This is a New Zealand case. At that time, New Zealand was also an English colony. Therefore, appeals went to the Privy Council of England. In this case, again, there was a company owned by Mr. and Mrs. Lee. Mr. Lee had 95% shares there. Mrs. Lee had 5% shares. It's an air farming company. You all know New Zealand is famous for farming. New Zealand, especially farming agriculture is New Zealand is that XME. We are called in one of these farm care at neck kid. It's like me. I think here is our baby business. They kind of my hurry farm chemicals on either fly for the time. The growth subject of so Lee was the main shareholder, having 9% of shares, main director, and also he was a fine. Right? So one day when he was fine, it crashed and he died. All the employees of the company were protected by workman compensation insurance. When his wife going to claim the insurance company argument that no, he is not done it. He can't be it. Because he is the main one of the main shareholders of the company. What do you think? Whether the main shareholder can be an employee of the company or not? Court decided at the time he dead, he was acting as a pilot. So he was a even though you own the company, still you can be an employee of your own company, right? No issue that way because company is separate, you are separate, shareholders are separate. So court decided he was entitled for the workman compensation insurance. This is also related to the insurance law. Macaura versus Northern National Limited, Company Limited. This is the Canadian case. At that time, Canada was also an English colony. therefore applicable to the English. In this case, Macaura was a timber merchant. And that's a huge country, isn't it? One of their main export is the timbers. So he had large number of timber, were billions. They all were insured under his own name. Later, he formed a company and transferred the timber to the company he formed. Unfortunately, as a result of a fire, large number of timber were burned up. Then he claimed the insurance. The insurance company rejected that. Right. The question was whether he was entitled for the insurance claim or not. Who it is? Insurance providing උත්තර දෙන්නත් පුළුවන්. Company වලින් උත්තර දෙන්නත් පුළුවන්. නේ? මම එකකින් හරි දෙකෙන්ම උත්තර දෙන්න. Macaura had a large number of timbers, all were insured under his own name. Later he formed a company and transferred all the timbers to the company he formed. Then they also fire and they destroyed. He claimed the insurance company rejected. What is it? Reject on the full on the balance. What is it? I'll look at the not get to have a down for a bite. They gave us done well. Who is it? I'll look at the back taking the unusual. What is something that they are? Life insurance, say, with pet insurance, you can balance. Well, we start to make a balance into the Alam with an giver. Yeah, take a part taking stolen subtle color, I'll check it. Life, life insurance, say, with pet insurance, we done not. I'll look with an angular person. Visa, who was the way they got? It's under the work around. What a case came down the floor with. Hey, baby. Nangi better than like you. Hey, baby. Hey, we start making insurance claim again the well. Yes. Insurance flow where it is. Come on, go to hey, Ben. There's no. Right? Right? There's no insurable interest. To insure something, you have to have a insurable interest. Actually, you have to prove it. Right? Okay, someone that is actually in this case, court decided that shareholders have no issuable interest in the company. Right? Shareholders have no issuable interest in the company. Company is separate, shareholders are separate. Right? Let me. Anungela issues right? Here issues was under the Macaura's name. He had the insurance, but he had no timber. Timber was belong to the company. Company had no insurance. Right? Company insurance again. Timber, you know, no insurance, then timber transfer. Right? The court decided shareholders different, companies different. Shareholders have no insurance insurable interest in the company. Right? You got it? DFCC Bank versus Mudita Pereira. decided in 2010 by Sri Lankan Court of Appeal. Any bankers? BSCC bankers are not. We get over that case. Make a mountain and it was the last lot of way. Where the case later. Right. So you all know what is meant by parate, right? Parate is done. Well, that is not I took that long. That's what is about that. Parate. Another part three, give me out to up the parate. Then I am the baby and I access the line. Colombo to get a maker. The whole person and I don't know what I got. And it's a legal term. We bear custom on that we can say. Doesn't it? Then after this, we are which one are we find my benefit. Lanka in me, I don't know. This is a privilege given to the bank. This is a privilege given to the bank for monthly cover. Right? The capital may make a bank for the privilege. According to the Parat execution, if a bank has given a loan to you, if loan amount exceeds 5 million, you fail to repay it, then what will happen? If you have a proper security, then according to the general law, they can go to the court and sell the property. But under Parate, bankers don't need to go to the court. If amounts exceed 5 million, they can directly sell it and encash it. Bank could do that privilege, right? Saman and Dimatia Lord Nagata make it well more than this. Bank could do Savigila, what or the Santama Galipuran. Bank could make a very time I got to take. Bank will loan the Gagato, bank would also have done that. Right? Do that. The Masuna Bella, Kelima, Ekabikuna, the money side. It is from the Palates. Usavi and the Lanka, without going to the court, they can sell it. It's a right privilege given to the bankers. Right? But for that, the loan amount must exceed 5 million. And security must be below to the borrower. Security guy are right way, 5 million word, right? In this case, DFCC bank has given a loan to a company. Right? Loan given to the company. Security was given by the director, Mudita Pere. Right? Obviously, company loan is more than 5 million. Right? Then as company failed to repay, bank tried to sell it by Parate without going to the court. But Mudita Pere argued that no, you can't sell it. Because property belongs to the third party. Loan given to the bank. Right? If a property belongs to the third party, then bank cannot exercise the power. Right? So the question was whether lender was a third party. In this case, Sri Lankan Court of Appeal followed a Solomon rule and decided that director is separate, company is separate, and therefore you have exercise. Right? So they follow the Solomon, right? So company separate, directors are separate. So the first case, Trade Exchange Zero Limited versus Asian Hotels Corporation. Here, Trade Exchange Zero Limited is a money chain, money exchange company situated within the hotel firms. Asian Hotels sale money that they will pass on. It does take it off. compare, like a money change, jewelry, or make a shop, a shop. Right. So, Asian Hotel Corporation were 95%. It was incorporated by Parliament Act. Incorporated by a Parliament Act. The 95% share belong to the government. And the board of directors were appointed by the list of board of the by the government. Financial assistance were given by the government. Right. So, this company, this hotel, expel this money escape company from their hands. Then they file a writ. Right? Writ can however, writ can only be filed against the government. Writ filed against the government will say, okay, to do something or not to do something, you can file a writ before the court of appeal. So, Trade Estate Limited filed a case before the court of appeal, asking that not to expel them from their office. But this can only file against the government. The question was whether Asian Hotels Limited was the government. What do you think? They can. Government or their agency, right? You can file a writ. Writ. Answer not pull on, answer the done. What do you think? Look at that can't go later. With the Asian Hotels Corporation represent the government or not? Oh, it is. Well, it is. 95% share of name by that there's it looks like a government agent, right? It looks like a government agent, but in this case, again, in 1981, Sri Lanka Court of Appeal followed the Salman and decided that even though all those were belonged given by the government, it is separately incorporated. Once company is separately incorporated, it's a separate person. Right? Therefore, government is separate, Asian Corporation is separate, because it is incorporated by a separate act. So they follow the Salman. Right? However, this case was criticized later, saying that it was one good example in Sri Lanka where they can go for an exception. Right? There are some exceptions to the Salman rule. What's the time now, Lavan? Huh? Because nowadays, sometimes the people, the court, will explain. Right? You use the concept of cooperation for proper purpose, then the court will honor you. You can use the concept of way of incorporation for the proper purpose. But if you use it improper, then the court will not look at it. Right? Then the court will lift the veil and check that there's a same person or separate person. They believe that it's the same person who used this concept for some improper purpose, then court will make their life. So court decided this one good example where it should have been decided as a government agent and it would have been issued. But it was not issued because they follow the Salman. But sometimes if we state to the court that if people use the concept of cooperation for fraudulent action, taxation, or some other illegal purpose, then court judges will lift the weight of incorporation, and there are some occasions where persons or directors might be liable. However, it is not the law, it is an exception. Right? Okay, then we'll continue this later next week. Right?